Number 1. The Sutton Hoo Ship Burial and the Treasure Act. You are Edith Pretty, and in the summer of 1939 you have just authorized a local amateur archaeologist to open the largest burial mound on your Suffolk estate, and neither of you has any legal framework for what is about to come out of the ground. The mound is 12 feet high. Basil Brown has already opened 3 smaller mounds on the estate and found nothing significant. What he finds in this one will be in a museum within 6 years, and in a law within 57. The first thing Brown identifies is the ghost of a ship, iron rivets in the soil tracing the outline of a vessel 27 meters long. Inside the ship's burial chamber, he finds a helmet, a shield, a sword, gold buckles, a purse containing 37 gold coins, and silverware bearing the marks of 6 different Byzantine emperors. Charles Phillips of Cambridge arrives and takes over the excavation. He calls it the richest archaeological find in British history. Then someone asks who it belongs to. The coroner's inquest convened to answer that question operated under treasure trove law unchanged since the medieval period. Treasure trove required that objects be made of gold or silver, that they were made by Romans or earlier, and that the original owner had intended to recover them. The Sutton Hoo burial failed all 3 tests. The owner had not intended to recover his burial goods, and Anglo-Saxon manufacture was not Roman. Legally, the treasure belonged to Edith Pretty as landowner. She could sell it, export it, or melt it down, and nothing in British law prevented her. She donated it to the British Museum. For 57 years after Sutton Hoo, finders of comparable treasure operated under the same coroner's logic. The 1996 Treasure Act closed the loophole by replacing the treasure trove doctrine entirely. The law that existed in 1939 meant that if Edith Pretty had wanted to sell the Sutton Hoo helmet to a private collector in New York, nothing could have stopped her. The coroner's ruling in 1939 was internally consistent with existing law. Treasure trove doctrine had functioned for centuries as the state's primary mechanism for recovering buried wealth. The donation outcome proved that voluntary compliance could produce the right result. A system that relies on the good faith of landowners, the argument goes, preserves property rights while protecting heritage. But between 1939 and 1996, the same legal gap swallowed dozens of significant fines. The Portable Antiquities Scheme's predecessor body recorded over 90 cases of legally exported archaeological treasure between 1950 and 1995. The 1996 Act was introduced after a working group documented those specific losses case by case. Sutton Hoo was the case study used to open that working group's first session. The law changed because the gap nearly cost England its defining national object. Pretty died in 1942 and never saw the helmet on public display. It went on view in 1945. It is now the face of the British Museum's Anglo-Saxon collection. The law, written partly in its name, came 57 years after the find, too late for everything found and lost in between. The Treasure Act protected future finds from private export. The next discovery required a law that could do something the Treasure Act was never designed for: stop a construction project already underway. Number 2. The Kennewick Man and Nagpra. In July of 1996, 2 college students wading in the shallows of the Columbia River near Kennewick, Washington, found a human skull in the riverbank and called the local coroner. The coroner called forensic anthropologist James Chatters. Chatters found a nearly complete skeleton eroding from the bank. His initial morphological analysis suggested features inconsistent with known regional Native American populations, and then the radiocarbon date came back. 9,000 years old. One of the most complete early American skeletons ever recovered. The Army Corps of Engineers, which owns the Columbia Riverbank, moved immediately to repatriate the remains under the Native American Graves Protection and Repatriation Act, NAGPRA, which requires federal agencies to return Native American human remains to culturally affiliated tribes. 5 tribes filed affiliation claims. Chatters and 7 other physical anthropologists filed a lawsuit arguing that a 9,000-year-old skeleton predated demonstrable cultural affiliation and that NAGPRA's terms therefore did not apply. While the lawsuit was pending, the Army Corps of Engineers brought in 600 tons of rock and soil and buried the discovery site. The burial happened 11 days after the scientists filed their complaint. The lawsuit ran for 8 years. In 2004, the Ninth Circuit Court of Appeals ruled that the tribes could not demonstrate the cultural affiliation NAGPRA required for remains of this age. The scientists studied the skeleton. In 2016, DNA analysis showed the Kennewick Man's closest living relatives were contemporary Native Americans. Congress had already amended NAGPRA in 2010 specifically to address ancient remains where cultural affiliation could not be demonstrated, creating a new procedure that did not exist when the Kennewick case began. The federal agency responsible for the discovery site buried it under 600 tons of fill material before the legal question of who owned the skeleton had been answered by any court. NJABPRE was written to correct a century of institutional grave robbing. Native American human remains had been systematically collected without consent and held without recourse by museums and universities across the country. The tribe's claim to Kennewick Man was culturally legitimate even if it failed the legal test the court applied. The Army Corps burial of the site was an attempt to prevent further disturbance of what multiple parties considered sacred ground, operating under obligations that ANAC-GPO imposed on federal land managers. The Army Corps buried the site 11 days after the scientists filed their lawsuit. The timing transforms an act of reverence into something that looks considerably more like evidence management. The 2016 DNA results, which showed Native American affinity and would have supported the tribe's position, were only possible because the scientists' lawsuit preserved access to the skeleton. Repatriation before study would have made those results impossible. The 2010 NAGPA amendment was written specifically because the Kennewick case exposed a gap. The original law had no procedure for remains old enough to predate any demonstrable tribal lineage. The Kennewick Man skeleton was repatriated to the 5 tribes in 2017 and buried in a location that has not been disclosed. Douglas Owsley, the Smithsonian anthropologist who led the scientific analysis, published his full findings in 2014. The 2010 NAGPRA amendment he helped make necessary is now the legal framework for every ancient American remains dispute. The skeleton that changed the law is in the ground again. Kennewick rewrote the law governing human remains. The next discovery required a law that governed something older and more politically difficult: the ground itself. Number 3. The discovery at Flag Fen and the PPG-16. On the 9th of September, 1982, a drainage engineer named Francis Pryor was cutting a new dike through fenland east of Peterborough when his mechanical excavator began pulling up preserved Bronze Age timber from waterlogged peat. The timber was 3,000 years old. The peat had kept it perfectly intact. No law required the drainage project to stop. What Pryor had found was Flag Fen, a Bronze Age platform and causeway built approximately 1,000 years before the Common Era. 900 meters of post alignment drove into the fen floor, preserved in anaerobic waterlogged conditions that had kept the wood, the tool marks on the wood, and the organic material packed around the posts in the condition of the day they were placed. Bronze weapons and personal ornaments had been deposited deliberately in the water beside the causeway, a ritual deposit spanning centuries of use. The drainage project Pryor was working on would destroy the causeway entirely if it continued on its planned course. Under 1982 planning law, archaeological significance was a material consideration that objectors could raise, but the developer was not legally obligated to commission an archaeological assessment before construction began. English Heritage lobbied for 5 years for a mandatory pre-construction survey requirement. Nicholas Ridley, Secretary of State for the Environment, refused on the grounds that such a requirement would add unacceptable cost and delay to legitimate development. Flag Fen was saved only because Pryor spent 3 years raising private funding and purchased the threatened land himself. Planning Policy Guidance Note 16, PPG 16, was issued in 1990, making pre-construction archaeological assessment mandatory for all significant development sites in England. For 8 years after Francis Pryor pulled Bronze Age timber from the ground, the law still did not require a construction company to stop before it destroyed what lay beneath. Pre-construction archaeological surveys add real cost and real delay to development. PPG 16's opponents argued that the planning system already allowed archaeological considerations to be raised by objectors without mandatory process. Voluntary compliance by responsible developers was increasing. Compulsion would add bureaucratic burden without guaranteed benefit. English Heritage documented 47 significant archaeological sites destroyed by development in England between 1982 and 1990 that would have been protected had PPG 16 been in force. Ridley's cost-benefit analysis blocking the policy used a sample of 6 development projects to estimate the financial burden of mandatory surveys. 3 of those 6 projects were later found to contain no significant archaeology. The cost estimate that delayed PPG 16 for 8 years was calculated from a sample that overstated the frequency of significant finds. Flag Fen itself cost Pryor more in private fundraising to save than a mandatory pre-construction survey would have cost the original drainage contractor. Flag Fen is now an open-air museum. Pryor's purchase saved approximately 12 acres of the original platform. The full extent of the causeway beyond the purchased land was built over before PPG 16 came into force. PPG 16 has been superseded by the National Planning Policy Framework, but its mandatory assessment requirement survives in every subsequent iteration. Every building site in England now requires an archaeological assessment because a drainage engineer pulled up a piece of 3,000-year-old wood. PPG 16 changed what developers had to do before they broke ground. The next discovery changed what governments had to do before they could decide a site did not matter. Number 4. The Vasa and Swedish Maritime Heritage Law. The Swedish warship Vasa sank on her maiden voyage in 1628, 60 meters from shore, in 32 meters of water, in full view of the Stockholm waterfront, and remained there for 333 years before anyone asked whether a law existed to protect her. Anders Franzen had been searching for the Vasa since 1953 using a homemade coring device. He located her in 1956. The Swedish state and a commercial salvage company began planning the raise before anyone formally checked whether maritime heritage law applied to a 300-year-old warship. The Vasa was raised in 1961. 95% of her original material came up intact. 64 bronze guns, rigging, sails, and thousands of artifacts including clothing, tools, personal objects, and the remains of at least 15 crew members. It was the most complete 17th-century warship ever recovered. The 1942 Ancient Monuments Act, which governed Swedish heritage protection, covered land sites explicitly and maritime sites in language that was at minimum ambiguous. The Neptune Salvage Company contracted for the raise under maritime salvage law, not heritage law. The Swedish state intervened to claim ownership only after the raise was complete. Niels Onlund at the Swedish National Heritage Board identified the legal gap immediately after the raise and put it in writing. Maritime wrecks over 100 years old had no automatic statutory protection in Swedish law. Between 1961 and 1988, 14 other significant Swedish wrecks were disturbed or destroyed by commercial salvage operators using the same gap. The 1988 amendment to the Ancient Monuments Act gave automatic protection to all wrecks over 100 years old in Swedish territorial waters. Between the Vasa's raising in 1961 and the law change in 1988, 27 years passed in which every wreck in Swedish waters had less legal protection than a Viking-age runestone on a farmer's field. The Vasa raise was a success. Commercial salvage operators had the equipment, the expertise, and the financial motivation that heritage agencies could not match. The 1942 Act's ambiguity reflected an era in which maritime heritage recovery was not yet a coherent field. The state's post-raise intervention showed the system could respond to significant fines without pre-existing statutory authority. But the state's post-raise intervention established ownership, not methodology. The raise disturbed human remains and dispersed contextual archaeological material that a heritage law excavation would have documented in situ. Onlund's memo to the Heritage Board, written within weeks of the raise, described the operation as an archaeological disaster that had produced a spectacular object. The 14 wrecks disturbed between 1961 and 1988 were identified by name in the legislative record for the 1988 amendment as direct consequences of the legal gap the Vasa exposed. The amendment was introduced to the Riksdag with Onlund's 1961 memo attached as a supporting document. The Vasa Museum opened in 1990 and is now Sweden's most visited museum. The human remains recovered during the raise were studied and reinterred in the museum in 2012. Franzen, who spent years searching for the Vasa before anyone knew whether it was legal to raise her, died in 1993 without having seen the law his discovery made necessary. The wrecks lost between 1961 and 1988 are not in any museum. Sweden changed its maritime law because of what was lost during one successful raise. The next country changed its law because of what was stolen after a discovery its own government made and then failed to protect. Number 5. The Sipan Royal Tombs and Peruvian Heritage Law. In February of 1987, looters broke into a mud brick platform mound at Sipan in northern Peru and began removing the contents of a sealed Moche royal burial that had been undisturbed for 1,700 years and the Peruvian government learned about it from a police report, not from its own archaeologists. The police report reached Walter Alva, director of the Bruning Archaeological Museum in Lambayeque, 2 days after the looting began. Alva arrived to find a burial chamber that had already been stripped. What the surviving context told him about what had been there was enough to understand the scale of what was gone. The Sipon lord was a Moche ruler buried around 300 of the Common Era, with the full regalia of royal authority, gold and silver headdresses, ceremonial weapons, beaded pectorals, and objects that had no parallel in any previously excavated Moche site. The looted objects appeared in European and American antiquities markets within weeks. Alva launched an emergency excavation and found a second royal burial directly below the looted one, sealed and intact. The intact burial documented in precise archaeological context exactly what the looted burial had contained. The objects were parallel, the arrangement was parallel, the regalia was parallel. Interpol traced 37 objects from the looted burial to dealers in Germany, the United States, and Switzerland within 18 months of the looting. Peru's 1929 heritage law established state ownership of all pre-Columbian objects, but had no international enforcement mechanism. The objects had been legally purchased by dealers in countries with no receiving state provisions. No law in Germany, the United States, or Switzerland in 1987 required a buyer to verify that an antiquity had not been recently stolen from its country of origin. UNESCO used the Sipon case as its primary case study for the 1995 UN-Droit Convention on Stolen Cultural Property. Peru's 2004 Law 28296 created a national registry and an international cooperation framework modeled directly on the Sipon experience. The objects from the looted burial were in European auction houses before the Peruvian government had finished writing its incident report. Peru's 1929 law established state ownership clearly and unambiguously. The failure at Sipon was enforcement, not legal framework. International dealers who purchased the objects could not verify provenance in an era before digital registries and centralized reporting systems. The antiquities market existed independently of the Sipon looting and would have created demand regardless of this specific case. Alva's documentation of the intact second burial established an itemized inventory of what the first burial had contained. The objects appearing in European markets matched that inventory object by object. 3 of the 37 traced objects were purchased by institutional collections, museums, and universities that had received Alva's published emergency excavation report before completing their purchases. Those institutions had the inventory. They chose to complete the purchase anyway. The 2004 Peruvian law included a due diligence requirement for purchasing institutions specifically because of those 3 transactions. Alva excavated 7 royal burials at Sipon over the following decade. The intact burials are among the best documented Moche finds in the archaeological record. 17 of the 37 looted objects were repatriated over a period of 20 years through a combination of legal action and diplomatic negotiation. 20 objects from the burial of a man interred 1700 years ago are still in private collections. The law written in his name has not recovered them. The Sipon law addressed international trafficking after the damage was done. The next discovery required a law that could address what happened before anything left the ground, because by the time it was found, it was already being sold by the piece. Number 6. The Cave of Altamira and Spanish Heritage Law. You are Maria de Sautuola, you are 8 years old, and in 1879 you have just looked up at the ceiling of a cave on your father's estate in northern Spain and seen paintings of bison that are, though neither of you knows it yet, 14,000 years old. Your father Marcelino recognizes immediately that the style matches the portable art objects being recovered from Paleolithic sites across France. He publishes his findings in 1880. The European archaeological establishment responds by accusing him of fraud. The establishment's position was coherent within its assumptions. Paleolithic humans were understood to be too cognitively primitive for figurative art of this quality. The paintings were too good. The most prominent voice in the rejection was Émile Cartaillac of Toulouse, who led the consensus for 22 years. In 1902, after comparable paintings were confirmed at Lamouth and Font-de-Gaume in France, Cartaillac published a retraction titled Mea culpa d'un sceptique. Sautuola had died in 1888, never vindicated. His daughter Maria was 14 when he died. The cave was open to mass tourism in the 1950s. By 1972, scientists monitoring the cave atmosphere found that carbon dioxide and humidity from visitors had begun visibly degrading the pigments. The cave was closed to public access in 1977. The Spanish Law of Historical Heritage, passed in 1985, established automatic protection for all sites of archaeological or artistic significance, created a national registry, and mandated conservation assessments for any site receiving public visitors. It was the first Spanish law to explicitly name cave art as a protected category. It was written partly in response to the Altamira closure crisis, and partly in response to accelerating looting of prehistoric sites across Andalusia. The paintings survived 14,000 years in a sealed cave and began dying within 20 years of the tourists who came to see them. Mass tourism to Altamira was a democratic achievement, World Heritage made accessible to ordinary people for the first time. The degradation was not foreseen in the 1950s. The science of cave atmosphere management was in its infancy. The 1985 law has protected subsequent cave art sites effectively. Altamira's damage was the consequence of understandable decisions made in a period before the necessary science existed. The science of carbon dioxide damage to mineral pigment was available before the cave was open to mass tourism. A 1954 report by Spanish conservators specifically warned that visitor breath would alter the cave atmosphere at Altamira and recommended a maximum of 200 visitors per day. The cave received up to 1,500 visitors per day at its peak. The report was received by the Directorate General of Fine Arts and filed without action. The 1985 law's automatic protection clause was written specifically because the Directorate General's handling of the 1954 report demonstrated that administrative discretion could not be trusted to protect irreplaceable sites from institutional inertia. Altamira has been effectively closed to public access since 2002, with visits limited to 5 people per week for conservation research. A full-scale replica called Neo Cueva opened adjacent to the original cave in 2001. Maria de Sautuola, whose upward glance in 1879 started everything, died in 1946. The paintings she found are deteriorating slowly in the dark, and the law written to protect them came a century after the discovery and too late to save them. Altamira's law came after the cave began to die. The next law came after something was destroyed so completely that the discovery proving it existed was almost destroyed alongside it. Number 7. The Dead Sea Scrolls and Israeli Antiquities Law. In 1947, a Bedouin shepherd named Muhammad ed-Dib threw a stone into a cave at Qumran on the northwest shore of the Dead Sea and heard pottery break, and the legal battle over what was in that pottery would last longer than most of the countries involved in it. The scrolls passed through an antiquities dealer in Bethlehem. Eliezer Sukenik of the Hebrew University acquired 3 of them before the 1948 war made further negotiation impossible. The remaining 4 were smuggled to the United States and advertised in the Wall Street Journal in 1954. 11 caves at Qumran eventually yielded fragments of over 900 manuscripts. Among them were the oldest surviving copies of every book of the Hebrew Bible except Esther, alongside sectarian texts, hymns, and legal documents from a Jewish community that had lived at Qumran until the Roman destruction of 70 CE. Roland de Vaux assembled an international editorial team and negotiated exclusive publication rights to the full scroll corpus. The team published slowly, a handful of texts per decade. By the time Israel took control of the Qumran site after the 1967 Six-Day War and inherited the publication arrangement, the team had been working for 20 years and the majority of the scroll fragments remained unpublished. John Strugnell controlled access to the largest and most significant collection of fragments. Scholars outside the editorial team were denied physical access to unpublished texts. In 1985, journalist and scholar Herschel Shanks began a sustained public campaign in Biblical Archaeology Review, demanding open access, publishing accounts from excluded scholars about the restrictions' effects. In 1991, Ben Zion Washolder and Martin Abegg released a computer-generated reconstruction of unpublished texts assembled from citations in published scholarship, without authorization. The same year, the Huntington Library in California released photographs of all scroll fragments in its collection and declared them open to any researcher. The Israeli Antiquities Authority's response was to formally end the exclusive publication arrangement. The 1989 Israeli Antiquities Authority law, which had established the IAA the year before these events, included an access provision requiring that antiquities held under IAA authority be made available to qualified researchers, a clause written specifically to prevent monopoly publication agreements. For 44 years, the most significant manuscript discovery in the history of biblical scholarship was controlled by a committee that could exclude any researcher it chose, and no law required them to share what they held. The editorial team was assembled for genuine scholarly reasons. Translation and interpretation of ancient manuscripts in multiple dead languages and scripts requires specialist expertise that cannot simply be democratized without cost to accuracy. Monopoly publication was the standard model for major discoveries in the mid-20th century. The pace of publication reflected the genuine difficulty of the material. Open access without scholarly framework produces misinterpretation rather than knowledge. The monopoly publication model was abandoned by every other major archaeological project during the same period. The Nag Hammadi Library, discovered the same year as the Dead Sea Scrolls, was fully published within 20 years. Internal correspondence from Strugnell's own team members, released after the monopoly ended, showed complaints about the publication pace dating from the 1970s. Those complaints were not made public while the monopoly held. The 1991 computer reconstruction was made by scholars who had been denied access, working only from published fragments. When checked against the original texts after access was opened, the reconstruction was confirmed as accurate, demonstrating that the access restrictions had no scholarly justification that the unauthorized work could not overcome. The full corpus of Dead Sea Scroll texts is now available in digital facsimile through the Israel Antiquities Authority's online database. The 44-year publication delay means that interpretive frameworks built during the monopoly period are now being contested by a generation of scholars who had no access to primary texts during their formative training. Strugnell was removed from the editorial team in 1990 following a published interview in which he made anti-Semitic statements about Judaism. He died in 2007. The access provision in the 1989 IAA law that his tenure made necessary is cited in every subsequent Middle Eastern Antiquities Access Agreement as its model. The Dead Sea Scrolls law addressed who could control a discovery after it was made. The next discovery required a law that addressed who was responsible when a discovery was made and then ignored. Number 8. The Amsterdam Jewish Quarter Excavation and Dutch Heritage Law. In 1972, construction crews building the Amsterdam Metro began excavating through the former Jewish quarter of the city and found, at regular intervals, the basements and personal possessions of households that had been emptied by deportation between 1941 and 1943. The objects were in place, the furniture was in place. The archaeologist Hertje reached the site and understood what she was looking at. The Amsterdam Metro's Waterloopelen station required excavation through the physical heart of what had been one of Europe's largest urban Jewish communities before the war. Approximately 75,000 people had lived in the quarter. Deportations to the death camps began in 1941. By 1943, the quarter was effectively empty. 29 years later, the Metro excavation was cutting through intact basements that had not been entered since their occupants were taken. Furniture remained where it had been left. Household objects, personal documents, and children's toys were in the rooms. Hertje argued to the city that the deposits were archaeologically significant and required documentation before destruction. The city refused, the Metro was behind schedule, and the construction cost of delays was already significant. Hertje escalated directly to Mayor Ivo Samkalden. Samkalden halted construction for 3 weeks and authorized an emergency documentation survey. The survey produced 840 photographs and a 14-volume catalog of the material found in the documented section. The objects were subsequently transferred to the Jewish Historical Museum. The Dutch Monuments and Historic Buildings Act was amended in 1988 to explicitly include sites associated with the persecution and deportation of civilians as a protected heritage category. It was the first European law to name this class of site. A city was digging a railway through the physical evidence of its own wartime failure, and the law that was supposed to protect historic sites had no provision for sites that were only 30 years old. The Metro was infrastructure Amsterdam genuinely needed. The 3-week halt was costly. The basements were not ancient archaeological deposits, and their protection was not the intended scope of the existing Monuments Act, which had been written for medieval and earlier material. The documentation survey Samkalden authorized achieved the preservation goal. The material was recorded and transferred to a museum without requiring permanent legal change to accomplish it. The 3-week halt documented a fraction of the affected excavation zone. After the halt ended, the remainder of the Waterloopelen excavation continued without systematic archaeological survey. The 14-volume catalog covers the section Hertje was able to document, not the full extent of the disturbed quarter. The 1988 amendment was introduced to Parliament with an explicit reference to the undocumented sections of the Waterloopline excavation as the specific harm the amendment was designed to prevent in future. Its sponsor, MP Hedwig Spoor, stated in her parliamentary introduction that the law was being written to make mandatory what Sam Calden had done voluntarily, because the system could not rely on every future mayor being Sam Calden. The objects from Hirsch's documented section are in the Jewish Historical Museum and form the core of its material collection from the deportation period. Hirschi continued working in Amsterdam city archaeology until her retirement. Sam Calden's 3-week halt, taken without any legal obligation, is described in the 1988 Amendment's parliamentary record as the act the law was designed to institutionalize. The section of the Waterloopline excavation that proceeded without documentation after the halt is gone. The Amsterdam law named persecution sites as heritage for the first time in European law. The next discovery forced a law that named something harder to define, the rights of a living community to the archaeology beneath their own land. Number 9. The Native Title Act and Brewarina Fish Traps. The document that triggered Australia's Native Title Act was not an archaeological report. It was a High Court judgment delivered on the 3rd of June 1992 in a case about a small island off the Queensland coast. But the stone fish traps at Brewarina, built into the Barwon River in New South Wales perhaps 40,000 years ago, were the physical evidence that made the central argument possible. The fish traps are a network of stone weirs and channels extending across the full width of the river. They were constructed by the Ngemba people and used continuously for fishing across an estimated 40,000 years. They are the oldest human-made structure in Australia and among the oldest in the world. The Ngemba had managed the traps across a period of time longer than agriculture has existed anywhere on Earth. European settlers began fishing the traps intensively in the 1850s. By the 1880s, the fish populations had been depleted to the point where the traps no longer functioned as they had. The New South Wales government declared the Barwon River a public waterway in 1892 and excluded the Ngemba people from fishing there. The traps were heritage listed in 1977. The listing protected the physical stones. It gave the Ngemba no right to use them, no right to manage them, and no standing to object to decisions about the river that affected them. The Mabo judgment, delivered by the High Court in June of 1992, established that native title to land and waters could survive colonial acquisition where continuous connection could be demonstrated. Gillar Michael Anderson, a Maori elder, an advocate for the Ngemba, argued before the NSWA Land and Environment Court in 1994 that the Brewarina fish traps were precisely the physical proof of continuous connection that Mabo described. 40,000 years of uninterrupted construction, maintenance, and use, written into the stone of the riverbed. The Native Title Act, passed by the federal parliament in December of 1993, 6 months after Mabo, created the legal mechanism through which that argument could proceed. A structure built 40,000 years ago, used continuously for 40,000 years, was heritage listed in 1977, and the listing gave the people who built it no right to use it. The 1977 heritage listing protected the physical traps from destruction. Heritage law and access rights are distinct legal categories, and conflating them misunderstands the purpose of each. The Native Title Act required complex legislative balancing of competing property rights that had accumulated over a century of colonial land management. The physical evidence of the fish traps was powerful, but native title outcomes were not determined by physical evidence alone. The 1892 exclusion order was issued 23 years after the same NSWA colonial government had commissioned a survey of the fish traps that described them as an extraordinary feat of hydraulic engineering. The commissioners who wrote that survey and the legislators who excluded the Ngemba from the river were operating within the same administration. The heritage listing in 1977 used the 1869 survey as its primary supporting evidence. The listing document named the Ngemba as the trap's builders and designers while simultaneously designating the NSWA Fisheries Department as the responsible management authority. The federal parliament's passage of the Native Title Act was explicitly opposed by the NSWA Fisheries Department on the grounds that it would complicate river management on the Barwon. The department that had excluded the Ngemba in 1892 was still arguing against the legal recognition of their connection in 1993. The Brewarina fish traps are now managed jointly by the Ngemba community and the NSWA government under an agreement reached in 2000. Anderson's 1994 argument before the Land and Environment Court was cited in the Native Title Tribunal's procedural guidelines as a model demonstration of continuous connection through physical structure. Eddie Mabo, whose name is on the judgment that made the Native Title Act possible, died of cancer 4 months before the High Court delivered its decision. The Ngemba people had been excluded from the river for 101 years before the Joint Management Agreement restored their access to the traps their ancestors built. The Native Title Act addressed continuous historical connection to land. The last law on this list addressed something more immediate. What happens when an underground discovery proves that a government's official account of recent events is false? Number 10. The Srebrenica mass graves and international forensic law. In July of 1995, approximately 8,000 Bosniak Muslim men and boys were killed near Srebrenica in eastern Bosnia, and the primary physical evidence that turned a disputed atrocity into a legally established genocide was found underground in mass graves by a team of forensic archaeologists working without any legal framework that had been designed for what they were doing. William Haglund arrived as chief forensic investigator for the International Criminal Tribunal for the former Yugoslavia in 1996. He found graves. He also found that the graves had been disturbed, bodies moved from primary burial sites to secondary locations by heavy machinery in an organized attempt to conceal the evidence before investigators arrived. The ICTY had commissioned forensic excavation of mass graves to produce evidence for criminal proceedings. The chain of custody protocols for human remains as criminal evidence were adapted from domestic homicide investigation standards, procedures designed for single bodies, controlled scenes, and established jurisdictions. They were not designed for mass graves containing hundreds of individuals, distributed across a landscape in a post-conflict zone with active security threats. The defense teams in ICTY proceedings challenged the evidence handling repeatedly, arguing that the adapted protocols were inadequate for mass grave contexts and that the chain of custody for specific remains had been broken. In the Krustic trial, the proceedings that produced the first legal finding of genocide at Srebrenica, the defense's challenge was sustained in 3 specific instances. Those 3 instances related to the identification of specific individuals. For those individuals, the evidentiary standard was not met. Haglund resigned from the ICTY in 2001 following an internal review that found systemic documentation failures in the forensic process. The International Commission on Missing Persons, established in 1996, developed new DNA-based identification protocols that have since identified over 8,000 individuals from Srebrenica-related grave sites. The Rome Statute, adopted in 1998 and entering into force in 2002, included the first international legal definition of forensic evidence standards for mass atrocity investigations. Those standards were written with direct and documented reference to the ICTY's experience at Srebrenica. The investigation that established the legal definition of genocide at Srebrenica was conducted without a legal standard for how to conduct it, and the defense used that gap to challenge the evidence in court. The ICTY was a new institution operating in circumstances for which no precedent existed. The forensic teams worked under genuine security constraints in an active post-conflict environment. The documentation failures identified in the internal review were procedural, not substantive. The core physical evidence of the mass killings was not affected, and the genocide findings stood. The Rome Statute standards that emerged from the ICTY experience represent genuine progress built on genuinely difficult conditions. The 3 evidentiary failures in the Krustic trial were not peripheral. They concerned the identification of specific individuals whose families were waiting for legal confirmation of their deaths. The defense challenge was sustained for those individuals, meaning they were not legally identified in that proceeding. Haglund's internal review found that the failures were systemic. The same documentation gaps existed across the full scope of the investigation, not only in the 3 instances the defense successfully challenged. The review recommended standards that, had they existed in 1996, would have prevented every successful defense challenge. The ICMP's DNA protocols, which now provide the most reliable identifications from the Srebrenica graves, were developed precisely because the excavation documentation was insufficient to support identification through physical characteristics alone. The DNA work was necessitated by the failures the internal review documented. The Srebrenica graves are not fully excavated. As of the most recent ICMP published report, the remains of approximately 1,000 individuals from the Srebrenica killing have not been located. Amor Masovic has led the Bosnian Missing Persons Institute search for 25 years. The Rome Statute forensic standards he helped shape through the ICTY experience are now the legal baseline for every international war crimes investigation conducted under ICC jurisdiction. What connects these 10 discoveries is not the scale of what was found underground. It is the scale of what was missing from the law when the finding happened. Every legal change on this list was written in the space between what existed and what the discovery required. The law is always late. It is written by the thing that falls through the gap, not by the people who designed the gap to catch it. If these are the patterns you want more of, subscribe. The gap between discovery and law has more stories in it than any of them got credit for.